principles that work for you.
Thanks for joining us and welcome to another episode of Make Sense. Today we tackle a very morbid but also important topic on the issue of estate planning. And after a loved one passes, we often deal with the intimidating process of a probate. And sometimes it comes back and we know that the paperwork isn't straight. Joining us to discuss this and more is an award-winning and noted attorney, Jacy Whittaker. Jacy will be with us right after this break. Let's welcome Jacy Whittaker to the show. Jacy, good to see you, man. How have you been?
I'm good. Good to see you, Adrian.
All right, good. So before we get into any questions, just wanted you to tell the audience a bit about your background and a bit about what you've been up to in the last few years.
Okay. I'm an attorney practicing out of Freeport, Grand Bahama. I handle a lot of contentious probate issues, in addition to general commercial litigation and maritime litigation. In the past few years, we've focused a lot on maritime and commercial litigation. The probate litigation has slowed down, but it has started to pick back up with the recent things happening in the world at the moment. So we're just happy to be here and happy to contribute however we can.
Thank you so much again for being here and sharing your expertise in a very important topic. Jacy, we want to talk about estate planning. Estate planning is a very, very integral part of the overall financial planning scope, but also it's a topic that's shied away from because it deals with death and what possibly may happen to those assets that you accumulate over your lifetime and how those are ultimately distributed. And it goes into the first question. Does an asset die when an owner dies? I mean, what happens if I have accumulated over my lifetime all of my possessions? Do those die as well? What happens there?
So there's a very limited class of assets that die upon death. But talking about assets in general, the assets don't die. When you die, you leave everything behind. And it's sometimes very hard for people to actually sit down with an attorney like myself and plan their death, because that's really what you're doing when you talk about estate planning. You're sitting down, you're accepting the fact that one day you will die, and you have to be a very strong person to do that. And a part of being a strong person in doing that is that you're actually making it easier for your beneficiaries, be that your spouse or your children or your grandchildren. You're actually making the transition of your death easier for them in administrating your assets after you die. It's a very touchy topic, and you know, we often see people who will ask us about it, and then they will go away for a few years, and then they'll come back. And in the worst cases, when we see those people again, or we see the children or the spouse, the person has died, and now it's a fight because nothing was put in place, or it wasn't put in place properly. And now you're going to spend about 4 to 5 years in court paying huge legal fees. And that's something we try to avoid. As much as lawyers like to make money, we also don't like to fight when it doesn't make sense. So estate planning really plays a crucial role in avoiding that conflict and that bitterness when someone close to you has died.
Nicely said, Jacy. Makes sense for us, the statement, my loved one passed and the paperwork wasn't straight. We often hear that, and we often hear about it in colloquial terms. I mean, but here at home, that's what we hear. Yeah. The paperwork wasn't straight. And there's often a long legal fight that, as you said, is painful. But the notion of a will is very common. Do we use a will in common day? Is it very effectively? Are we effective with our use of a will?
People in the Caribbean, not just the Bahamas, we do not use wills efficiently because we all have this fear of death. We all feel that we can do it tomorrow. We can do it next week. And especially in these uncertain times where you can talk to someone today and, within a week or two, or you go on Facebook and you see that person has died. Now is a very important time for everyone to really, accept that we will not be here forever and draft up a will. Now, when you meet people that say, my paperwork wasn't straight or my parents' paperwork wasn't straight, it's because that person started the process of creating a will. And, I think out of just not knowing, I wouldn't say ignorance, because ignorance is when you know and you choose not to, but just out of not knowing, a will is a very simple document that you can go into an attorney and you can get done for a few $100s. It's not expensive. It's actually probably one of the most affordable services you can get from a lawyer. And all you're doing is you're going to that lawyer and you're saying, look, this is what I own. These are my bank accounts. These are my insurance policies. Can you please put these together in a document? And you have two people sign it. You need two witnesses, and a few other people sign some stuff. And lawyers do what lawyers do, and that's it. Now, a lot of people don't do that, and you're faced with this situation where a mother or father will die, and you leave a child having to call. And we've seen this before, and we see this a lot. That child will then have to call every attorney in Grand Bahama saying, did you know my mom? Did you know my dad? And then they'll have to go to Nassau. And then during this time, they're trying to marry their parents. And they can't, they know their parents had an account at Scotiabank or Royal Bank, and they can't access that money because there's a certain procedure in place that lawyers need to help you with. And it's one of those things where all of those, or not all of those, but any one of those touch points in that process I just described can generate the statement, my father's paperwork wasn't straight.
JC, I mean, it's such a morbid topic, but we're getting a little deeper and deeper, and we're unraveling some of the mechanisms that you would have experienced in your practice. But tell me again, when a loved one dies, the first step being having an attorney to help draft a will. When is the ideal time to have this? Do we wait until we feel like we're going to die? But death is uncertain and it can come at any time. When do you recommend that somebody sits down and starts to seriously think about the assets that they've accumulated and who they want to distribute it to after they die?
The minute you own a piece of property, and when I say property, I don't mean a car or a boat. I mean, once you buy land, you should create a will. That's what I would say would not be too early, and it would not be too late. And what you can do is you don't have to update your will every year. A lot of attorneys will tell you you need to do this every year. No. We suggest that for every property purchase you make, or every significant purchase you make, be it stocks, be it shares in a company, but every significant move that you make, you should update your will. So if you're 21 and you buy a piece of property, you should create a will. And if you buy another piece of property while you're 21 or 25, you should update that will to include. And as you grow and you start developing your portfolio, you should continue to update your will. Also, Caribbean people are very secretive. So, and this is just a bit off topic, but a lot of people don't like to write down everything that they own on a piece of paper for a variety of reasons. But something you need to understand is that whatever you have done with your lawyer is confidential. And you do not need to publicly file this document, this will, where everyone can see what you own. This document stays between you and your attorney. And we would always suggest that you maybe tell one or two of your children that Jacy Whittaker has your will. So if something were to happen to you, or your little brother or your little sister, so that if something does happen to you, they know where to look. They know where to start in tracing down what you owned while you were.
Nicely said, JC. I want to touch in on a point that you made, or a word that you use, and it's called probate. A lot of folks may be unaware as to what the probate process is like. If I have a will, I pass on, that will has to now be probated. What are the steps that actually gets the assets into the hands of somebody that I would have bequeathed it to?
Okay, so the probate process, you have two types of estates. You have people who die intestate, and you have people who die testate. To break it down in very simple terms, you have people who die with a will and people who die without a will. If you die without a will, you have to apply to the court, to the probate court, which is a division of the Supreme Court, and you have to ask for letters of administration. Those letters of administration give the person applying the right to administer the deceased estate. On the other hand, when you have a will, you apply for a grant of probate. And that will is submitted to the probate registry. And in that will, the deceased person would have made a decision on how his assets are to be distributed upon his death. So just going back a bit, when you die without a will, there are certain rules of inheritance that apply. And let's just let's take a real life example, because not every family is perfect. If you have a father who has two sons, or let's say you have a father and a father, to use a very Bahamian example or a Caribbean example, you have a father who was married and they had a child. The father and the wife separated, but they never got a divorce. And they hate each other, but they have a child who is of age. The father and the son have a very close relationship. The father dies. The son thinks that he is going to inherit everything because they had a close relationship. But under the rules of inheritance, because the father and the wife never got a divorce, that wife, his spouse, gets everything. Mm. And this exhibits why it's important to have a will, because we've seen cases where parents and their kids just don't get along, and these are real life facts. Not everyone lives in a movie. You have cases where parents and children just don't get along, and the parents will rather leave all of their property to a distant cousin than leave it to their child. And this is the benefit of having a will. So going back to the process, so you have a letters of administration for when you die without a will, and you have a probate for when you have a will, and the deceased person can decide who gets the property that he left behind.
Very interesting points. JC, the other question that may emanate from the process is, if I hire an attorney, I have a will, I'm going through the probate process, my biggest question is time frame. What would you say would be the average time frame to get an estate settled or a will settled? How long does it take? Is it 6 months? Is it 40 years? Is it 2 years? What can we expect, or is it just a case by case basis?
We can actually say that within the last, I would say 10 years, the probate process has gotten a lot faster due to new regulations, new systems being put in place by the Supreme Court. And we would estimate right now that if there's no one challenging a will, and we can talk about how you can challenge a will later, but if there's no one challenging a will and we're just going through the normal procedure, our record, and I can't speak for other firms, but we usually are able to turn around a probate within 2 to 4 months. This is compared to 10 years ago, where a probate would take about a year or two.
Okay, no, that sounds pretty reasonable. 2 to 4 months. I mean, for most families that are still in the grieving process, 2 to 4 months may be, depending on the family, pretty reasonable. Now, you raised an interesting point, and we have to touch it. What can go wrong in the estate planning process as it pertains to wills? So
there are a lot of things that people overlook when are dealing with the estate of someone who has died. For example, there's a process called a caveat. So most of the commercial banks in the Bahamas are aware of a caveat, and they monitor the obituaries to see which one of their customers have died. It's very sad. It happens. And so if you had a loan at a bank, whatever bank that may be, they will enter a caveat against your estate being probated. And what a caveat against your estate means is they will put a temporary block or a temporary objection on the court file. And what that requires you to do as the beneficiary of the estate or the executor of the estate, sorry, not the beneficiary, as the person actually carrying out the process of doing the probate, you have to contact that bank and say, I acknowledge your debt that you had with the deceased, and upon my obtaining probate, I will come in and settle the debt with you. So the point is that even when you die, the bank still come after you. Another thing that can happen is where a beneficiary is, and we see this a lot, is complaining about, oh, that was my father. I know he loved me. He left everything to me. He didn't mean to leave it to my younger brothers and sisters who weren't there. Well, sometimes people are, different than what you think, what you see when they're alive. We've had a lot of cases in the past and heard from other attorneys as well. You will have something called an excluded beneficiary. So an excluded beneficiary is someone that is not named at all in the will. They didn't get anything, and their brothers and sisters got all of the property and all of the cars and all of the assets. They will then try to challenge that will. And there are a number of grounds that you can challenge a will on. One is mental capacity of the testator, being the person who wrote the will. If the person was suffering from a lack of understanding, and that covers more topics, but if he had a lack of understanding of what he was doing, and you can prove that, the will may be able to be set aside. And if it is set aside, then it goes into the laws of inheritance, and you go to the wife, and then the wife and the first child, and so forth. There are also some other simple cases. We see a lot of people printing wills online, and they'll print a will and sign it and not have anyone witness it, or not have enough people witness it, and those wills are technically invalid. So although they had a good intention in doing a will, because they didn't execute the will properly, the will is invalid, and someone can challenge the will on that basis. And we've done a number of those as well.
So
Jacy, there are other grounds.
No, so Jacy, I just had a quick question to ask. For a lot of married couples that may have a will, for instance, husband and wife are married, wife creates a will, joint assets are owned, wife passes away, and now the husband is still alive. Does he have an obligation to carry out the wishes of his deceased wife?
Is there a will in place?
There is a will in place on joint assets.
On joint assets. So when we're talking about ownership of joint assets, there are two types of ownership in joint assets. You can either own them as a joint tenancy, or you can own them as tenants in common. And a joint tenancy situation is different from a tenants in common situation, because in a tenants in common situation, although you are two owners to one piece of property, you as the husband can leave your share of that property to someone totally unrelated to your wife. And your wife can do the same thing. She can leave it to her sister or anyone else. In a joint tenancy, there's a right of survivorship. So where there's a husband and wife who owns a property under a joint tenancy, if one person dies, the other party automatically gets the property.
Despite a will being in place?
Yeah, because the will would not fall in a joint tenancy situation. The property that is owned as a joint tenancy falls outside of the will.
Okay, fair enough. Fair enough. Jacy, I know that there are a number of instruments that can be used in the estate planning process. We talked pretty extensively just a second ago about wills, but let's talk about trusts as well. Trusts have a unique feature where You can go to an attorney's office, I understand, and you can set up a will and a trust. But with a trust, you can establish it during your lifetime and amend it as needed. And there isn't a probate process where you may transfer the ownership of the asset during your lifetime to that trust. Tell us about the trust process, and is it better or worse than having a will?
So it really depends. And the thing that it really depends on, and it's sad to say, is the cost. A will, on average, a very simple will, you can probably spend $1,000. And if you never update that again in 30 years, you would have only spent $1,000. When you get into the creation of a trust, although the initial fees can range anywhere between $2,500 to maybe $10,000 to $20,000, depending on how many assets you own, the carrying costs with the trust are more. You have annual trust fees, you have trustee fees because you need to appoint a trustee, which is usually a professional trustee, and you need to pay them. Usually these are accountants or lawyers, so you're getting a billable hour every year. So for most people, when they come into our offices and they say, I want a trust, we explain both options. This is a will, which you can update every year. Or if you really want a trust, this is how much it will cost you. In certain other instances, not just estate planning, trusts are necessary. Sometimes you have business people who would like to create asset protection trusts, which will shield them from any potential liability. These are also used in those instances. But it really depends on the needs of the client and the assets and the holdings of that client, which will offer greater protection. Because if you're not in business and you just own property, and you don't see any liability coming your way, then a will is fine. So the trust is really for unique individuals.
Okay, fair enough. The cost, so it can be cost prohibitive, but the question though is, can a hybrid instrument be created where you have a will, which doesn't have as much carrying cost, and upon your death, it can, your assets may be able to go into a trust that can be distributed according to the will of the deceased. Is that a feature or?
Yeah, it is a feature. So let's say, for example, that you have a person who creates a will, and within a will you can create a trust. But when you're talking to a lawyer about wills and trusts, they're two separate trains of thought. But there are unique situations whereby a will can create a trust. So, for example, if you are a young parent and you have, let's just use an example of a $5 million life insurance policy, and you have a minor child of maybe 4 years old, and you die, but you left the will in place for this insurance policy for your 5-year-old child. Now, the proceeds from your insurance policy will be paid to your estate, to your executor of your estate, who would have been appointed after completing the probate process we talked about earlier. Now, in your will, you can put that money, the $5 million, into trust for your child who is 5 years old. And in your will, you would have spelt out what you want to be spent on your child, who her guardians or who his guardians will be, and you would also specify at what age the child would be able to access those trust funds. So there are hybrid situations that come about, usually when you're talking about minors. Some people also want their children to pursue higher education. So, you could say that the child has to obtain a degree before they are able to access the trust funds. But those are the trusts that are created out of wills. But when you talk about trust, like we did earlier, you're really talking about, releasing yourself from being the beneficial and legal owner of title. And just to explain or expand on that a bit more, whenever you see a piece of property, be it a piece of property in COS Village or Bahamia, there are two owners to each piece of property. And the two owners are, you have the legal title, the title of whoever the title is registered to, their name, And then you have the beneficial title. And the beneficial title is the beneficial owner. So in most cases, a person will be the beneficial and the legal title owner. But in trust situations, you actually release the beneficial ownership to the trust. So you actually don't own the property, although your name is on it. And that may be the segment for another podcast.
No. We're going to hit right into that now. Can't open the Pandora box and just leave it all exposed. So if I get you correctly, and help me to understand what you just said, you basically said that a piece of property has two owners.
Yes.
If a single individual owns that property, there's still two owners. There is the legal person and the beneficial person.
Yes.
Legally, my name can be on a conveyance, but beneficially, I can be holding it in trust for whomever third party there is.
Yes. And currently there's no requirement to show the beneficial ownership of land. The government recently passed some legislation this year, which will require a beneficial ownership registry as it relates to companies. Because, with the Bahamas being an offshore center, there are a lot of companies out there that are, legally held by someone who works in a company somewhere, but not beneficially owned by them. But as it relates to land in the Bahamas, there's no requirement to disclose beneficial ownership in land.
Hence, that gives rise to the efficacy, I guess, of land trusts. In that sense, you can't have a legal owner that's a trustee, and the beneficial owner can be the settlor, if we use the fancy language, or the person that simply owns the property outright.
Yes.
I want to take the time to kind of expand on that point of land, and it's very simple. The whole notion of land being the greatest asset in terms of size that most persons would own. What recommendations do you have during your lifetime to ensure that land successfully passes on? We can establish a trust, but do we also need to look at property taxes? How does tax impact your ability to transfer assets? I mean, if you have a huge tax liability out there and you have all noble intentions to pass a piece of property that you've been holding on for a long time to your kids, is there an obstructive process in between that transaction?
So surprisingly, properties that are conveyed from a deceased estate to a beneficiary you don't have to pay stamp tax on that. There's an exemption in the Stamp Act, which doesn't require you to have to pay 10% of the value of the land to transfer the property from the estate to the beneficiary. So when creating the estate plan, that is the tax issue from a transfer tax isn't something that necessarily comes into play. The only thing that would come into play would be, real estate property tax, depending on which island you live in. But that would be something else.
Okay. And I guess my penultimate question would be, we talked a lot about assets in the estate process. We touched on very briefly debts in the estate process. How important is it to disclose your debts in a scenario where you're naming your assets in a will, but there may be alternative claims on you as a person, or a mortgage in place, or some other obligation that is owed? Do those somehow attach themselves to the probate process or the trust distribution? So
in the probate process, it's mostly, I've only ever seen the banks really go after by filing a caveat. But if you were involved in litigation whilst you were alive, there's no restriction on anyone filing a caveat against an estate. So yes, your debts do pass on to your estate once you die. Once you die, you still owe bills. So your executor, there's usually a clause in your will that your executor will pay all debts that are due. So usually when you die and their debts, the debt collectors will contact your executor, and your executor will pay those bills before, and it's his obligation, his or her obligation, to pay those bills first, and then to distribute the remaining assets to the bank.
So, JC, want to ask a very hot topic question, one that is top of mind for a lot of folks, and that is the whole idea of generational property. I know for years and years and years, you'd see a family on a plot of land or large plots of land, and somebody passes on, and there's a fight about ownership. Tell me about generational property and some of the benefits, and also some of the unfortunate incidences that you may have seen during your practice.
All right, so generational property is a very hot topic in the courts. It probably amounts for maybe 50% of the land title claims before the Supreme Court, and it boils down to people being afraid or feeling that they can't reach out to an attorney to discuss these issues, because a lot of these issues could have been solved had the grandfather or the great grandfather just simply talked to an attorney. Generational property. What we see is that the property would have been owned by someone back in maybe the 40s or 50s or 60s. That person would have died, and that person would have left a will, and someone or the executor or the children did not think that they needed to probate the will. And if they did probate it, they did not see the need or understand the need to transfer the property out of the estate. So, and this is a reoccurring misconception I see on a daily basis. When someone dies, the executors hold on to the property for 20 to 30 years, and they never distribute the property from the estate of the deceased. It is not the duty of the executor to hang on to the property and to dictate how the property is to be used. The executor's job is to simply apply for probate and distribute the property. So when you talk, in most cases in generational property, there would have been a person, let's just say great grandpa died, and grandpa was supposed to probate it, and grandpa didn't probate it, but he told all of the 10 grandchildren that this section is yours, this section is yours, this section is yours. And those people then build their houses on the property, and then their children now live in the property, and someone dies. And then they start fighting over where the property line is and who owns this, and everyone's pulling out the conveyance from 1960 and showing a drawing somebody did that wasn't actually legal. And then one person will break free from the group and apply to court to quiet the property. And then the other 9 children or 9 individuals will then object because they feel like that one person is taking all of the property away from them. All of this, in most cases, I shouldn't say all, it arises from a lack of communication. So the best thing to do is, if there is a situation of generational property, we would always suggest that all of the members come together and we have a big group discussion whereby we tell them that they should instruct the surveyor to actually go in onto that tract of land and actually survey the property, and everyone would agree on the lines as much as we can, and then the entire group can go to court because title is now cloudy. So the entire group will then apply to the court for to quiet the property, and really, quieting of titles is really just to calm down the title issue, and get the court to confirm that the property has passed correctly. And that's my ideal world, but it doesn't happen like that. So you usually have everyone just going to court and 10 attorneys showing up and everyone fighting and requiring the judge to go and visit the property and see who owns what where. But all of it really can be avoided if people just communicate. But it's very, very sad to see that some of the instances that arise in the court.
Absolutely, and communication is key. So, JC, I want to thank you for being on the show. Lots of great information that you've passed on to us. Very important points indeed. My final question, though, as you survey the landscape, the next 10 to 15 years, or even now, what's your hope for the estate planning process in the Bahamas? And is there anything that you would like to see highlighted going forward as it relates to wills, trust, and the whole notion of transferring assets to our loved ones once we pass on?
I really think that the legislature has put in place what we need to utilize. I think that the courts have also taken steps within the past years to get us to a point where it's not a headache now to have a probate done or letters of administration. Also, our probate courts are very on top of the ball and, settling estate disputes and getting those, out of the way. Like you said earlier, people are grieving. The last thing they want to do is to fight in court, although it happens a lot. In the next 20 years or so, I really hope that individuals will become more aware of the need to estate plan. Because anytime, me as a child growing up, anytime I heard the words estate planning, I figured that was for rich people only. But really and truly, if you own a lot, in Arden Forest or, Shannon or Midshipman Road, and you should plan for your estate. That is your estate. That is what you are leaving to your family members. So we need to get rid of this notion. And I think through shows like this and other means, we just need to continue to educate people that wills are for everybody. Wills will save your family a lot of grief when you're gone. And we just need to, take advantage of the resources that we have available to us as individuals in the Bahamas.
JC, thanks so much for making sense of real estate matters and trust and probate matters. JC, where can people find you in case they wanted to take a deeper dive into any personal questions that they may have? For the benefit of our audience, can you leave some contact information and let us know where we can find Jacy Whittaker?
Sure. You can find me at pariswhitaker.com. That's PARISWHITTAKER.com. And you can always call me, 242-806-0880. A lot of attorneys won't give you their mobile number, but you can feel free to reach me at any time. I'm open to anyone.
Thanks again, JC. And to our audience, thanks for joining us on another episode of Make Sense. We'll see you next time right here, same place.
Watching RBNTV. We are networking, promoting, we're scoring points.